Hello, I'm Charlie Plumb with McAfee and Taft's Employment Practice Group, and we're going to be discussing pregnancy in the workplace issues. And let me tell you why that's a big issue today. First of all, the Equal Employment Opportunity Commission has made it a real point of emphasis. They've just issued their strategic enforcement plan, and when you go through that plan, what becomes very obvious is the EEOC is really going to emphasize investigating and enforcing pregnancy discrimination and pregnancy accommodation issues in the workplace going forward for the next several years. And one of the biggest indicators of what their intentions are have been a series of press releases here in the last several months, really advertising and getting out there how much they are intending to enforce and prosecute allegations of employment discrimination based on pregnancy. So that's telling us something right now that you as employers and HR professionals need to be really aware of where we're headed in that direction. Another factor has been the enactment of the Pregnant Workers Fairness Act, and that went into effect last summer. And that's intended to broaden the protection that our federal employment laws afford pregnant employees and fill some gaps between some existing federal laws. So that tells us that's going to become a bigger part of your lives as employers and HR professionals going forward. Finally, really a practical indicator here at McAfee and Taft, we're seeing a real uptick in getting questions from employers about pregnancy issues, questions they have in the workplace, and that all tells us that we're going to be facing more and more of those questions, and you need to be armed and ready to address those sort of issues. So joining me today is Connor Curtis, also with our Employment Practice Group. And what we wanted to do in our discussion today is really explain to you what you need to be anticipating, what you will be seeing in your workplace with your workforce when it comes to pregnancy issues, and also giving you some direction on how to respond and kind of best practices going forward. So what we're going to do today is really go through the federal laws in place, including the new Pregnancy Workers Fairness Act, how they overlap, and suggest to you some approaches and hopefully kind of sensitize you to some of the issues you're going to be seeing going forward. So with that, Connor, why don't you start out and kind of explain to us how Title VII, kind of one of the foundational federal employment laws, how that addresses or how that covers pregnancy in the workplace issues, if you would.
Absolutely, Charlie. So Title VII prohibits discrimination in the workplace based on a variety of protected characteristics. Now, Title VII was amended by the Pregnancy Discrimination Act to add pregnancy to that list of protected characteristics. So what that means is that an employer cannot discriminate against an employee based on a current pregnancy, a past pregnancy, an intended or potential pregnancy, as well as any medical conditions related to pregnancy.
Okay, that sounds pretty broad. So give us some examples. Obviously, if an employee is pregnant, that's going to trigger Title VII. What are some other circumstances that Title VII might cover when it comes to pregnancy or pregnancy-related issues?
So you're correct that is incredibly broad. And so an example of a medical condition related to childbirth would be in vitro fertilization, which is very common these days. So it would be prohibited under Title VII to discriminate against an employee based on their decisions surrounding IVF treatments. Okay. That would also include an employee's choice to use contraceptives or not use contraceptives, as well as an employee's choice to get an abortion or even simply contemplate getting an abortion.
What about any sort of related post-pregnancy conditions? Are any of those covered by Title VII and its anti-discrimination features?
Yes. So lactation would actually be a great example of a post-childbirth condition that would be covered under this prohibition on discrimination.
Okay. So it can't discriminate against employees based on their need to participate in post-birth lactation.
That's correct.
Okay. So we talked about discrimination. Are there any other coverages for Title VII when it comes to pregnancy?
Yes, so Title VII also prohibits harassment based on pregnancy, and that would also include those pregnancy-related medical conditions. An example of harassment would be unwelcome jokes, ridicule, offensive statements. And like I mentioned, it doesn't just have to implicate pregnancy. It could be an offensive joke about how many children an employee chooses to have, or a joke about whether or not an employee is using contraceptives or not. That would be included under this Title VII prohibition.
Okay, so that is a wide coverage for Title VII for discrimination.
Absolutely.
Title VII is an anti-discrimination law, doesn't really touch on accommodation. Do I have that right?
That is correct.
Okay, so let's move to the Americans with Disabilities Act. And I don't commonly think of a pregnancy or a pregnancy condition as a disability, but can that be covered by the ADA?
So pregnancy itself is not a disability under the ADA, but a pregnancy-related condition can rise to meet that definition.
Can that be both a medical condition or limitation pre-birth as well as post-birth?
Yes,
Okay.
that's correct. And so an example of a pregnancy-related condition that could rise to that level would be preeclampsia or severe high blood pressure. Usually an employee or a pregnant woman who is experiencing preeclampsia has to be hospitalized. That would likely be a pregnancy-related condition that would meet the level of a disability under the ADA.
Well, and you know, you may run into, I guess, employees that are pregnant that may have prenatal diabetes. Would that be something that might rise to the level of the ADA?
Yes, that would be another example.
Okay. The ADA would cover both pre-birth and post-birth medical conditions if they were sufficiently severe to rise to the level of disability. Is that right?
Yes, that's right.
And my memory is the ADA also covers not just physical limitations or conditions, it also attaches or applies to mental conditions or limitations. Any examples you might share with us of post-birth medical conditions that might apply to the ADA?
Absolutely. So an excellent example of that would be postpartum anxiety or depression. That would likely be a mental condition that could rise to the level of a disability.
Okay, so let's assume that we're dealing with an employee whose medical condition, either pre-birth or post-birth, rises to the level of disability. The examples we've been discussing, what rights or what protections do they have under the ADA for those circumstances?
So as an initial point, an employer is prohibited from discriminating against that employee on the basis of that disability. But the employer is also obligated to offer a reasonable accommodation for that disability to the employee.
Okay, so on the discrimination piece, in this situation, it would be possible when an employer is addressing pregnant employees' concerns or complaints, they would face, when it comes to discrimination, potential claims both under Title VII as well as the ADA.
Yes, that's correct.
And then the what sort of process or protocol should employers and HR professionals use in terms of speaking with and working with pregnant employees when it comes to the accommodation issue for pregnancy?
So when determining a reasonable accommodation for a pregnant employee, that process will look just like any other accommodations process. The employer should meet with the employee, determine their needs and what possible accommodations would work best for that employee, as well as the essential functions of that employee's job.
So we're talking about the interactive process and the consideration of accommodation for pregnancy-related issues, just like we might for a back issue or a heart issue, something like that.
Yes, that's right.
Okay. Now, at the beginning, I mentioned the Pregnant Workers Fairness Act, the PWFA. That went into effect, I believe, in the summer of 2023. Yes. Tell us how that works. And I'm really interested in understanding what distinction employers and HR professionals need to keep in mind when they're looking at the PWFA as opposed to a disabilities issue under the ADA.
The PWFA fills in the gaps of the ADA. And what I mean by that is that it has a much broader coverage and it will include many more conditions that maybe don't meet the requisite level that is required under the ADA. It might be a condition that technically doesn't qualify as a disability, But under the PWFA, the employer would still be obligated to accommodate that employee. So under the PWFA, an employer is obligated to accommodate an employee for known limitations. So a known limitation is a condition, whether it's mental or physical, that is arising out of childbirth or pregnancy or related to childbirth or pregnancy.
But it doesn't hit the seriousness or the severeness of a disability.
Correct.
Okay.
So an example of this would be morning sickness. Morning sickness likely doesn't meet the definition of a disability, but under the PWFA, it would be a known limitation that the employer is obligated to accommodate.
Okay. Maybe a pregnant employee might be also facing mobility issues or restroom needs that aren't hitting that disability mark as well, but would be protected by the PWFA. Is that realistic?
Exactly. And so examples of reasonable accommodations under the PWFA might be moving an employee's office to where it's closer to the restroom, or maybe offering that employee a parking space closer to their office. Those reasonable accommodations for an employee are going to be determined on a case-by-case basis, but this is just to give you all an idea of what might be a reasonable accommodation. So that could look like job restructuring or perhaps a modified work schedule. Like I mentioned, an employee who has morning sickness, maybe you modify their work schedule to where they aren't in the office during those morning hours.
Or perhaps more breaks if necessary
More breaks
to get through the day.
Yes, that would be an excellent example. It might also mean allowing them to work remotely or work on light duty.
And, I think one thing that is important to keep in mind, we're used to in the context of Americans with Disabilities Act or the FMLA, we're going to talk about here in a moment, we're used to the ability to require supportive medical documentation. That is some sort of documentation from a healthcare provider that backs up an employee's request or need for accommodation. One thing that's a little bit different in the PWFA, not only is the level of medical condition or limitation less than the disability of the ADA, under the PWFA, there are certain what they call simple accommodations where no medical documentation is needed. You gave as an example the need for additional breaks or perhaps improved parking situation. Those sorts of things under the PWFA, the employer is supposed to consider and grant if reasonable, even in the absence of any formal medical documentation, simply based on the employee's representation of that need. So that's something to keep in mind, and it distinguishes it. We get in a mode, I think, to ask immediately for some medical documentation for accommodation. Some of these accommodations under the PWFA, that is not necessary, nor do you have the right perhaps to ask for those. And that's going to be decided on kind of a case-by-case basis. Question now on the PWFA, they released proposed regulations in August of last year. Those aren't finalized yet. They haven't been specifically approved. Are they valuable? Are they helpful to employers even though they're not finalized?
Yes, they are incredibly helpful to see how the EEOC is planning on enforcing the PWFA. It is, in a way, a sneak peek for us employers to figure out what we are going to be obligated to do under the PWFA. So while they're not finalized yet, they're still very helpful. Well,
and keep in mind, we talked about the EEOC has sent us a very strong message of being very active when it comes to pregnancy-related issues in the workplace, discrimination, accommodation. I think Connor's exactly right. Even though they're not final and haven't been finalized and formally adopted, they really are a roadmap of what's going through the mind and what the intentions of the EEOC are. So now let's talk about the Family and Medical Leave Act, and we know there's going to be some overlap here. There are some rights for pregnant employees. Let's cover that. So we keep our eye on another law that may kind of layer over what you're already dealing with pregnant or post-birth issues with your employees.
Absolutely. So under the FMLA, an employer is required to provide up to 12 weeks of leave for childbirth, for prenatal care, for incapacity related to childbirth, or for serious medical conditions that arise after childbirth.
So they still have to be an eligible employee under the FMLA. I have to have worked with you for 12 months and I have to work the requisite number of hours.
Yes.
Okay. And it's up to 12 weeks, meaning if I've used some weeks before for other medical conditions, I only get additional time.
Yes, that's correct.
What about, this made me think of something we didn't talk about under the PWFA. Would a possible accommodation under the PWFA, let's assume I'm not eligible, I haven't worked a year yet, or let's assume I've expended some or all of my 12 weeks of FMLA, could a possible accommodation be giving me additional unpaid leave?
Yes, that would be an option.
Okay, I switched over. Let's go back to the FMLA, okay? So what sort of rights, again, could be pre-birth or post-birth, but it's a medical condition that's serious, like a disability, and I've got this FMLA right. What rights do they give me? Does that give me?
So this FMLA protected leave means that an employer cannot interfere with that leave, cannot restrain an employee from taking that leave, or outright deny that leave. It also means that when an employee returns from taking FMLA protected leave, then they have the right to assume that same exact position that they had held before or the equivalent.
You know, I mean, if it's not clear yet, I want to just say this out loud. You know, what I'm really taking away, particularly with the laws we've talked about so far, Title VII, PWFA, and the FMLA, in terms of leave, in terms of discrimination, in terms of accommodation, you as employers and HR professionals, you're going to have to keep your eyes on all these different issues because they're going to frequently overlap when you have questions or concerns from your workforce, from pregnant employees. Now, the last law we're going to talk about, I don't think of as pregnancy related, the Fair Labor Standards Act, but there's been an amendment that the FLSA comes into play a little bit here too. Can you tell us about that?
So the FLSA has been amended by the Pump for Nursing Mothers Act, or the Pump Act. And what that does is it obligates employers to provide reasonable break times to their employees who need to pump throughout the workday, as well as provide a private space to do so. Now that space, it cannot be a restroom that is explicitly provided for by the law. Gone are the days of women having to pump in the restroom stalls. Even if this is a private restroom, it still cannot be the space that employers provide to those employees. So the space must be private. It must be protected from intrusion by coworkers or members of the public.
Like a lock on the door?
Yes, and it has to be freely accessible to that employee, though, throughout the workday. So you have to make sure you aren't locking those employees out who need to use the room.
Now, how many breaks am I entitled to under the Pump Act in the course of my workday?
So it's going to vary, and it's going to depend on what that employee needs. So the number of breaks throughout the day, the length of those breaks is just going to depend on the situation. It just has to be reasonable.
What does that look like? A break, meaning what happens during that time?
So, Charlie, this is very important to note. An employee has to be relieved of all job duties while they are taking those breaks under the Pump Act, or else they need to be paid for that time.
All right. And what about how long does that right last after I've had a child?
So it lasts for 1 year following childbirth. And another interesting point about the Pump Act actually is that it applies to remote workers as well as in-office workers.
Okay. Well, thanks. That's very helpful. One thing I hope that comes across loud and clear is you're going to be facing and dealing with more and more issues involving pregnancy or pregnancy-related issues in the workplace. The EEOC has really telegraphed and communicated their intention to be very active and very proactive when it comes to these issues. We've got a number of employment laws that come into play and overlap. You're not going to be dealing necessarily with just one particular requirement. We're going to have to keep in mind all the laws that Connor's been talking to us about and all their rights involving discrimination, accommodation, and those types of issues. So in terms of best practice, I think start with updating your policies, your EEO policies, your anti-harassment policies, and your accommodation policies to recognize these new obligations and related obligations for pregnant employees, both pre-birth and post-birth, and really spend the time making sure our supervisors are sensitive to these issues, that they recognize when they're dealing with or potentially dealing with pregnancy or pregnancy-related questions when it comes to the people they work with and supervise. So we're prepared, and you're prepared to address them properly in this more and more emphasized area that you're going to be facing as an employer and an HR professional. Connor, thank you for all your time and your thoughts, and thank you all for spending some time with us in this discussion.